question is, if you see there's a parallel statistics that today itself, that the ED has taken more action in the last 5 years or 6 years than it has taken in the entire preceding 10 years. It's gone up by something like 42 times. 42 times. So that is what speaks for itself. The question of use and misuse would rest on the premise of more data like this. Do you require either the previous regimes were all foolish, they didn't apply it, or this regime is on some other mission? So you have to come to such conclusions.
All right, and I'm being joined by my colleague Meenakshi Bhanja live on the broadcast, who's reporting from the national capital and tracking the story very, very closely. Meenakshi, please take us through the contents of this key judgment that has been delivered by the top court.
Well, yes, you see this is over 500 plus page ruling that has come by from this three-judge bench composition of the Supreme Court. We are in possession of the ruling and the important part, like you have referred to earlier, has been how the Supreme Court has upheld the stringent provisions of the PMLA. There were a batch of about 241 petitions, mostly filed by the accused. We underline for our viewer that the PMLA is a special law. It is a special act which is carved out to deal with certain niche offences, and these petitioners were assailing certain provisions dealing from section 3 to 5 to 11 to 19 to section 45 of the PMLA, which includes a range of powers that has been vested with the Enforcement Directorate, which currently is probing a lot of allegations pertaining to money laundering and other such related allegations, specifically with regards to the opposition parties and some leading opposition leaders in India. So with regards to that, the Supreme Court has today very categorically upheld that there are certain safeguards that are already made out within the ambit of the PMLA, and with that the Supreme Court has upheld the stringent provisions of the PMLA, which gives the Enforcement Directorate unbridled powers insofar as making an arrest, a seizure of property, or getting a confession, and also sees to it that bail conditions are very hard and bail is very difficult to come by if anybody is been slapped with any charge again under the PMLA. Furthermore, like you were referring to a little while earlier, the Supreme Court has said that as far as money laundering provision is concerned of this particular act, money laundering is no less heinous than terrorism. These are very scathing observations coming from this 500 plus judgment of the Supreme Court, where the court is saying that money laundering activity has a transactional impact on the sovereignty and integrity of countries. So therefore that provision which deals with money laundering has also been kept untinkered by the Supreme Court, and this gives a boost to ED, because remember, as we speak, there are several cases slapped against leading opposition leaders.
Correct.
That the ED is in the midst of investigating. So had Supreme Court today made any adverse comment or tinkered with any of these provisions, then the ongoing investigations definitely would have taken a hit.
All right, Meenakshi Bhanja, appreciate you joining us with all those key details. All right, and on this very note, I'm in fact being joined by another gentleman to share his 2 cents on this entire story, Mr. Aashutoshsrivastava, advocate from the top court, Supreme Court. So a very, very good evening, and thank you for your time to Mirror Now. I want to begin here by asking you that how do you view this judgment? Do you think somewhere this is a big blow to the constitutional rights of an individual, and in this particular case, the alleged accused?
MLA is a 2002 act, and since then nobody thought of making any amendment or changes in the act itself. So it is being continued in the similar manner. Now, so far as the powers of the ED officers are concerned under the act, see, they have the powers under section 50 of the same act to summon anybody or to have the search and seizure of certain documentations and others. They have the powers under section 5 to have the provisional attachment of the properties. See, it is not absolute. After any, if a person is aggrieved by any such order or action of the ED, can obviously approach the concerned court and can ask for the indulgence of the court to supervise the issue and to pass certain directions and orders to the ED, which is happening since long years, and this is being followed in the similar manner. Yes, it is expected out of the ED officers that they will use their powers judiciously, and they will do nothing injustice to any of the accused for that matter. Obviously, they have the powers as per the Act itself, and this is what the Supreme Court has clarified after examining all the documentations on record, after hearing both the parties at length, all their arguments, all their reasonings, and then the Supreme Court reached to a conclusion that obviously the ED has the powers as per the Act. See, the courts are not making laws. The courts are only executing what laws have been passed. The courts have to only see if any law which has been made is not unconstitutional, or it is not against the principles of justice and the Constitution of India. And this is what the court has seen. And after having regard and going into the depth into the matter, the court decided that yes, the powers of the ED officers cannot be snatched away, which has been given by the Act itself, which was enacted in 2002. And accordingly, the court passed an order. If anybody is aggrieved, then can approach the court. See, there could be a case, a particular case in which the power has been misused or something. So in that case, a person can approach the court to have its indulgence, which is happening as of now. But there cannot be a blanket kind of an order where the powers can be snatched away and this kind of offences are happening. See, everybody cannot be the culprit, but whoever does it, for them only the law has been enacted.
All right, sir, but this judgment, this judgment, I completely get your point, but this judgment also comes in at a time when, several opposition leaders and in fact human rights bodies have been echoing the constant misuse of the central agencies, and this move now only further empowers both the ruling dispensation and the agencies. What do you have to say on that?
See, in that case, if they feel that there has been misuse of powers, they need to prove it in the court. They cannot prove it on the streets. It has to be proved before the concerned court or before the higher courts to the judges as to what kind of powers have been misused, whether the laws have not been followed, whether they are not at all guilty. There is no prima facie case against them. There is nothing which has been found against them. There has nothing which has been done wrongfully by them. There is no sort of any money laundering in that particular case. This is what they have to prove before the court. If they are not able to prove it, if they are failing to prove it, obviously if there is a prima facie case against any accused or a person or a company, the ED has certain powers as per the law to proceed, and this is how they are proceeding. Obviously, there could be instances where there is no prima facie case. In those kind of cases, many high courts have also given no coercive action orders. Many of the courts have also stayed the summons issued by the ED for any such probe. So this is what is happening. See, ED is not having absolute powers, but it has to be further controlled and supervised by the superior courts. And this is what has been happening as of now. So as per my opinion, if there is any misuse, it should be proved before the court of law. And we should have some kind of faith in the judicial system, and we should have confidence in the laws which have been enacted by the parliament. These are the MPs who make the laws. Right. So they only have made the laws. If there was something wrong with the law, they could have changed it in the parliament in these all long 20 years. This is a 2002 Act. Now we are in 2022. Now we are asking the court only to first the parliament makes a law and then it demands changes from the court.
All right.
So that is also has to be seen.
All right, sir, one final question before I let you go. What are the possible ramifications of this verdict, and what are the options that are available for all the accused persons in such cases?
Yes, see, as per section 45 of the PMLA, one can apply for bail. There are two conditions to be fulfilled. One is that the public prosecutor in the case has to be given opportunity to oppose the bail, and the person has to prove that the person is not guilty of committing any sort of money laundering, and then these two conditions if fulfilled, the court has the powers to grant bail to the accused. And in addition to that, a person can also approach the High Court for quashing of any such kind of summons being issued or to a stay if there is a prima facie case in favor of the accused and against the ED. In those cases, it can happen. If under Section 5, if there is any provisional attachment of properties by the ED, the same can also be argued upon in the court of the adjudicating authority. And if the person is not satisfied with the order of the adjudicating authority, can also be challenged before the appellate court, and thereafter it can be further challenged before High Court or the Supreme Court. So all these options are available for anybody who feels that there has been wrong case being filed against that particular person and there has been misuse of any law. The laws and provisions are very clear. They have all the rights to approach the appropriate courts to get justice.
All right, yes. Mr. Aashutoshsrivastava, thank you so much for your time to Mirror Now, and definitely, so that's the latest that we're picking up. Remember, the top court in a very, very key judgment has only upheld the powers of the ED. And on this very note, in fact, we have another big breaking news coming in from the aviation sector. And massive setback to the airline SpiceJet. Now, in a big crackdown on the SpiceJet, aviation regulator, the DGCA, has in fact confirmed that 50% of the SpiceJet flights have been grounded. In view of the findings of the various spot checks, inspections and reply to the show cause notice submitted by the SpiceJet, the number of departures of the SpiceJet is restricted now to 50% of the number of departures approved under the summer schedule of 2022 for 8 weeks from the date of issue of the order. Remember, this very important development comes in at a time when there have been several cases over the past 2 months, cases of mid-air emergency, cases of divergence, that only raise pertinent questions over the operations of the SpiceJet and the safety of the passengers. On this note, I'm being joined by my colleague Samir on the broadcast. Samir, please tell us this latest. All right, we are still trying to connect with Samir, but that's the latest that we're picking up from the aviation sector. Remember, this has been in news for more than a while now, and with several cases of mid-air emergency divergence coming to the fore. Now, the latest is that in a massive setback to the SpiceJet, the DGCA has confirmed that 50% of the SpiceJet flights have been grounded. And remember, this comes amid findings of various spot checks, inspections, and the recent reply to the show cause notice that was submitted by the SpiceJet. So that's the latest that we're picking up on the SpiceJet grounding. Remember, 50% of the SpiceJet flights have been grounded for 8 weeks now. A step that has in fact been taken to ensure that proper checks are conducted when it comes to the safety regulation. And remember, in latest now, the DGCA, the aviation regulator, has confirmed that in view of the current findings and inspection, 50% of the SpiceJet flights to remain grounded amid safety concerns. All right, and on to some breaking news coming in from the state of Maharashtra. In a big decision by the new Chief Minister Eknath Shinde, electricity has been made cheaper for the farmers. Now, power has been in fact made cheaper by 1 per unit for the farmers. So that's the latest that we're picking up in terms of the latest decision by the new Maharashtra Chief Minister Eknath Shinde. And remember, this comes in at a time when the CM has gone on to say that the step is taken to improve the power distribution system in the state. And on this one, I'm being joined by my colleague Abhishek live on the broadcast. Abhishek, a big boost to the agricultural sector. In fact, a very, very big announcement by the Maharashtra CM. What more can you tell us about this?
Definitely, again, today was the cabinet meeting by Chief Minister Eknath Shinde and Deputy Chief Minister Devendra Fadnavis. Number of issues were discussed, and one of the prominent issue that is of electricity, and this has been taken importantly looking after the flood-like situation across the state of Maharashtra. And this is the kind of a relief of 1 rupee per unit has been given to the agricultural sector, especially to those farmers who have been affected by the flood-like situation. And remember, this has been given amid the opposition is constantly hitting out at the government, telling that where is the cabinet expansion, one, and secondly, there are no guardian minister and other ministers to look out for the different districts which are suffering with floods. And going ahead, there are one of the important decision that was taken today was taking back cases of political and social protest which took place during the corona pandemic period. And remember, this entire case of coronavirus pandemic that has been slapped during the phase are being taken back, whether it is Ganesh Utsav or Dayandi period, that has been taken back. Remember, this is the time when MVA government was in power and these protests were taken by the BJP. And third, importantly, it has been also said by the Chief Minister that it has been closely monitored and the health department is on high alert when it comes to the monkeypox cases which has been found in the south of India, but everything is on high alert and necessary steps are taken in this regard. So definitely a big decision on the lines to the benefit for the farmers and the agriculture sector, also on taking back cases when it comes to corona pandemic violations, and importantly vigilant when it comes to monkeypox cases which are coming from the south. Back to you.
All right, Abhishek, thank you for giving us all those details. And time for a very short breather now, but don't go anywhere, for we'll be back soon with more news and updates.